This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judge McBrayer and Judge Armstrong, we're pleased to welcome Mr. Bryant and Mr. Gursky for this oral argument, which is being live streamed so that we can fulfill our obligation to keep our courts open to the public. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to present your case, and the appellant has reserved some of that time for rebuttal. So unless there are any announcements, I'll ask Mr. Hibner to call the case.
Debra Jean Griffith-Ball versus Stanley Lauren Ball.
Mr. Bryant, you have the floor.
Good morning, Your Honors. Thank you very much. My name is Daniel Bryant. I represent the appellant, Mr. Stanley Ball, a veteran of 34 years of the United States Army. This is an appeal from a divorce case from the Circuit Court of Montgomery County, and we appealed essentially two issues. Both are alimony issues, two different types of alimony. One was alimony in futuro in the amount of $2,000 per month owed to Mr. Ball's ex-wife, Ms. Griffith-Ball. The other form of alimony was alimony in solido, and that was a lump sum of $15,000 due immediately thereafter the divorce was finalized. We've appealed both of those issues, and we have no doubt that we have a tough burden. It's very clear in looking at the case law that the Court of Appeals does not like to reverse or remand alimony decisions, that the standard is pretty much an abuse of discretion standard, a standard that requires either a misapplication of law using the incorrect legal standard or a view of the facts that are so skewed that the evidence from trial does not support those findings. But I believe strongly that we have both of those things in this case. Starting with the alimony in solido, the trial court awarded $15,000, and the trial court essentially had two major reasons for their decision. And Judge Olita, as usual, was very thorough in offering reasoning, which is often good enough to overcome an abuse of discretion standard. However, the two things that were cited by the judge in this case were not properly done. The first reason she gave was that as part of this divorce, we agreed to divide Mr. Ball's military retired pay. That was an undisputed issue. And in doing so, wife received a little over $2,000 a month. That's not an issue at appeal. That's an undisputed fact. However, the trial court judge stated that since Ms. Ball did not receive, she essentially gave her an arrearage on military retirement. The trial court judge said, we are going to basically punish Mr. Ball and award Ms. Ball for not giving her part of the military retirement essentially as a pendenti lite matter. Of course, that was never requested. Nothing in the record to show that was ever a request of Ms. Ball. And the law on dividing military retirement, starting with the federal statute, 10 U.S.C. 1408, specifically says that you can only divide military retirement in a final decree of divorce, not as a temporary matter, not as a pendenti lite matter. Federal law says only as a final decree. And so to go back and say that, in fact, the trial court judge's word was Ms. Ball's entitlement to that award. But that's not proper because federal law says you only divide it at the time of the divorce finalization, not prior to that. And further, our own statute in Tennessee, 36-4-121, our property division statute says you divide property as of the value of the final hearing. And so that would be military retirement, it's property. You divide it at the final hearing, not prior to. So both of those were erroneous applications of law. Further, no actual calculation was even done. Even if that was proper, the trial court judge never went through and said, well, this is what was owed, and we're going to add it up times this number of months. That was never done. It was, at least as far as the record is concerned, an arbitrary figure.
Do we know in this record how much Ms. Griffith-Ball incurred in attorney's fees for the divorce?
Your Honor, that was my next point. The trial court judge also said, I'm awarding this alimony in solito for the purpose of attorney fees. But no affidavit of attorney fees was submitted. It was essentially just like with the figure on the retirement, it was kind of out of the blue. And I'm not saying that that's not a figure necessarily that an attorney might incur on a divorce case, but there was no actual affidavit, no actual testimony. Ms. Ball never testified under oath, I spent $15,000 or any other figure on attorney fees for my divorce. And it's my understanding in looking at the case law, in fact, there was their fairly recent case law on attorney fees where it has to be based on some actual calculation. It has to be based on something, typically an affidavit from the trial counsel.
But yeah, bottom line, your point is that to be able to say that a spouse has insufficient funds, you've got to know how much the spouse has to pay to make that initial determination.
Yes, Your Honor.
Okay.
And, I think the case law where there's no figure, no reasoning behind the figure have essentially resulted in remands to the trial court on that issue. But then my final point on the in solito alimony is, well, two more points. One, Ms. Ball, and the record reflects this in depth, Ms. Ball walked away from this divorce with $70,000 in separate assets, money, cash money, and over $200,000 of marital assets, the majority of which was also liquid assets. And case law on attorney fees tend to say, if you can pay your own attorney fees, then it shouldn't be awarded. And if she's got close to $300,000 of assets, she's got plenty of money to pay a divorce attorney for a divorce case like this. Finally, with that, back to the issue of the account or the arrearages, more or less, on the retirement, that retirement money was going into marital bank accounts, and the trial court made a meticulous finding regarding those accounts. And so that money was actually divided. And to say that she should get both a division of the accounts at the decree and an arrearage is a double dip. But I'll move on to the alimony in futuro. Alimony in futuro, in this case, the court applied what seems to be generally the correct legal standard, but a very skewed view of the facts. And I will specifically draw the court's attention to the wife's need for alimony in futuro. The Court of Appeals has held multiple times, and the Tennessee Supreme Court, that the biggest factor is the need of the spouse, second only to the ability to pay. In the trial court's ruling, she said that no one challenged wife's expenses. Wife presented a financial affidavit where she showed essentially $2,000 of need. And to say that that was not challenged is a very off the mark view of that. She testified at length about it on direct examination. Her attorney asked her about it. I asked her about it on cross-examination. And not only was it challenged, she testified to numerous expenses on her affidavit that she either didn't have, or she was uncertain of how much they actually were, or that in fact she pays less. And in our brief, we added it up and it comes to over $1,800, close to $1,900 of expenses that either don't exist or that are much less or not on a monthly basis. And on top of that, she is getting over $2,000 a month in military retirement from her husband's 34-year career. If she's getting over $2,000 in military retirement and she shows on paper a need for $2,000, that's convenient math that even an attorney can do. That comes to zero need. On top of that, with her expenses, by her own testimony not being what they were on paper, that cuts down on the need even more.
What's the two parties' net income without taking into consideration the alimony solido? I mean, wouldn't your client come away with a gross of roughly $10,000 a month, which I think is what the trial court found, whereas Ms. Griffith-Ball would come something not even half that, correct? Am I wrong about that?
Your Honor, we dispute that actually. As far as take the military retirement, we'll take it one piece at a time. Military retirement, we have total of $5,000. Wife getting $2,000, husband getting $3,000. We've got then Social Security, husband getting about $1,200, wife getting about $1,000. We then have husband's VA, which is about $3,000, and now he's got to pay $2,000 to her. So in fact, the parties are either coming out close to even, or possibly ex-wife coming out with additional income. And
well, but I mean, before, just based on the numbers you just gave me, I'm adding them up here. If we don't include any sort of infurturo alimony, Ms. Griffith-Ball would get $3,000, have income of $3,000 a month versus $7,200 for your client. So over double.
she's got her job, Social Security, and military retirement. So that would be more like $4,500. I think I'm out of time.
Any further questions from the panel? Hearing none, thank you, Mr. Bryant. We'll now hear from Mr. Gursky.
May it please the court, Steve Gursky of the Montgomery County Bar, and I'm here today on behalf of Ms. Griffith-Ball. And I appreciate Mr. Bryant's acknowledgement of the standard of review, because the lens through which we review this case today is basically acknowledging the fact that the trial court has very wide and broad discretion in making a determination as to the nature of this spousal support, the amount and the duration of the spousal support. So in this case, I think what the trial court well realized was that in all likelihood, a trial probably never would have been necessary, but for Mr. Ball's continued persistence on asserting that his VA disability income had no application and shouldn't be considered for any reason. As a result of him taking that position, I think the court acknowledged implicitly that, mediation failed, discovery ensued, and then we had a contested divorce trial. And now here we are on appeal, and they continue to assert, those same issues. At the trial level, Mr. Ball, he submitted an income and expense statement that he did not include his $3,100 of VA income because he just thought that shouldn't be talked about for any purpose. So he asked the trial court to disregard that. And then he also asked the court to ignore his Social Security income of $1,364 a month. And
but wouldn't you agree that Gonzewski is pretty strict on trial court judges about when they can award attorney's fees as alimony and solido. I mean, the Supreme Court pretty much dictated the circumstances there. And I don't find in this case where the court fit the award within those circumstances that the Supreme Court has mandated. So, I mean, is Gonzewski wrongly decided? Is there a reason why we can ignore it here? I mean, what's the situation?
Yeah, I think in this case, respectfully, that, you know, we understand the trial court has this level of discretion. We understand that. We understand that this was a 34-year marriage. We understand the massive disparity in income. The trial court obviously has a finger on the pulse of what it costs to try a contested divorce case in Clarksville, Montgomery County. And I think the court, you know, made some reasonable, you know, assumptions in this case as far as, you know, what was expended to put this case together, why this case, you know, had to be put together, what legal arguments were necessary to continue to explore. And then ultimately, I think the court took notice of the fact that Mr. Ball, throughout the duration and the pendency of this case, he had the benefit of all of that money. You know, he had the ability to spend all of that retirement income that otherwise, you know, would have been a marital asset. And Mr. Bryant makes the argument, well, that money was in an account and it was ultimately divided, but that begs the question that he had access to that money and he spent down that money, you know, during the pendency of this case. And that was, you know, ultimately, I think why the court justified award that, you know, all in all, you know, not a pretty nominal sum of, you know, alimony and solido. I would respect.
Well, I take it by your comment, though, that the trial judge, quote, had her finger on the pulse of what it costs to try a divorce case that there really wasn't any proof of what attorney's fees that your client incurred.
No, there was not any testimony, no affidavit, nothing like that. But she might have read some of, you know, I'm sure she read many Court of Appeals cases with a talented Helen Rogers, my good friend, and, you know, they know, you know, what it costs to try a case.
Yeah, I would say those are on the high end of the scale, generally.
I think Mr. Ball's, his central argument in this case today is basically that the trial court committed error when it found that Ms. Griffith-Ball had a need for future support. He basically asserts that the trial court erroneously concluded that she had a financial need. And then he takes the position that, you know, that the trial judge totally disregarded his very good cross-examination of my client with respect to her expenses. And I think what he argues is he's quick to point out that, hey, when this divorce goes down, I'm going to lose $200 from my VA income because, you know, I won't have a spouse anymore. But he totally disregards the fact that his wife of 34 years, who is of, you know, declining health, increasing age, that she's simply not going to be able to work any longer after this divorce. And she's going to lose $1,382 per month. I think there was documented proof at trial of what her expenses were, you know, despite Mr. Bryant's very good cross-examination and his criticism of those expenses. The trial court ultimately concluded that all in all, they were reasonable. And I just don't think it's outside the realm of reasonableness to say that incurring $3,900 to run a house when you have a mortgage and, you know, upkeep is that's just not, you know, that's reasonable. So as far as the question about the actual available dollars, if you look at the $3,900 in expenses that Ms. Griffith-Ball has, and you couple that with the retirement income of $22,050 that she gets, plus her alimony award and then her meager Social Security, she has a very small surplus to cover her expenses. So basically, she's in the position where she has to keep her fingers crossed and hope her car doesn't break down, that her water heater doesn't go out, you know, that you know, her HVAC system, or that her health doesn't continue to decline and she has an increase in medical expenses moving forward. And I think this discretionary process that the trial court has to engage in, you know, it requires some level of forecasting. You have to forecast a little bit. And I think based upon the fact of Ms. Ball's age, her health, the overall marital estate and other factors, that the court properly evaluated the evidence and made a conclusion that was well within the range of reasonableness. And certainly it wasn't contrary, I would assert, to the preponderance of the evidence. As far as the income that Mr. Ball receives, he gets $5,463 from his retirement. He gets $3,187 from his VA, and he gets $1,364 from his Social Security. So those numbers right there are about $10,000 gross pay. He then also receives, he has this house that he has a rent-to-own deal with his daughter, so he receives $500 a month payment from his daughter, and then he gets $300 for his for a car that he lent her money on. So he has another $800.
So was there proof from the record that those expenses that were actually paid by the daughter?
There was testimony about it. I don't think there's any dispute, but that he received those funds. I don't think that was a disputed issue. So he's of that income that he has, he's ordered to pay his ex-wife $4,050 when you count the retirement and the alimony. So from the $11,000, that still leaves him $7,000 per month, which clearly is more than what his need is, and he clearly has the ability to pay. I think, when the trial court heard this case, the trial court took note of the fact that this marriage really wasn't that strong for a pretty good period of time. And the trial court noted that Mr. Ball was very successful in separating his VA dollars. He kept them segregated, and he created a very substantial estate for himself when you consider the $103,000 in cash that was awarded to him separately, the $94,000 house, on Granny White Road that was awarded to him as his own separate property, plus his $25,000 truck. That was $222,000 that was totally carved out of the marital estate and segregated to him, that wasn't part of the equitable division. One issue that we briefed on appeal was the fact that perhaps the trial court committed error when it segregated those assets and said because they were, accrued with the VA disability money, because you could, quote, trace it, that the $94,000 house and the $25,000 truck, she excluded those from the marital estate. And some of the case law that I put in my brief, suggests that since these are not assets that he uses for his support and maintenance, they don't retain those qualities of monies for which the Supreme Court talked about, which is the test to determine if those assets have lost their exempt status. So arguably, we would argue that the $94,000 house and the $25,000 truck, should be added back into the marital estate and considered. But we argued in our brief that we would, in exchange for the alimony staying as is, we would waive that that request, and we thought that was reasonable. Mr. Ball, what he takes the position that his wife, who's 65 years old, that she should continue to work, but he shouldn't. And this is despite the fact that he has a higher education. He had a work history in the school system subsequent to his retirement and subsequent to his receiving disability, that his overall health is good, as evidenced by all of the activities and physical tasks that he participates in. And the truth is, he could supplement his own income if he wanted to, but what he told the trial court was that he said he didn't see the need to work, as he didn't want to take a job from somebody who really needs it. But on the other hand, he wants to sit here and argue that his wife should work. And the testimony at trial was that she would get up early, Ms. Ball, and she'd work all day, and she'd come home and she'd be very tired, and she'd essentially go to bed and get ready for another day, with these little preschoolers or kindergartners at the elementary school. And all the while that she's working and trying to recover, he's, traveling around with his lady friends and basically doing the things that he enjoyed doing. But yet at the same time, my client is fighting viruses from the little kids that she gets and generally just dealing with overall fatigue. And the trial court, trial court saw some level of planning by Mr. Ball, because the trial court mentioned the word stockpiling of assets, that he was stockpiling his assets. And I don't think the trial court was impressed with the manner by which Mr. Ball treated his wife. There's allegations of physical misbehavior and general harassment and intimidation, but the trial court did make a specific finding that it did not consider fault when making that award of alimony, didn't consider the fault. But I think it's very obvious, though, that the trial court carefully considered and weighed all of the factors, that were applicable. So essentially, our position is that when you analyze all of the findings of the trial court, and most importantly, the need and the ability to pay, that it's obvious that the trial court acted well within its discretion. And it just seems like it would be just a dangerous precedent to say a trial court who sat here, heard the testimony, and then just to reverse any part of an alimony award, even the Salito award based upon a 34-year marriage, and that trial court sat there and heard that evidence. So we would ask the court to respectfully affirm in all respects.
Let me ask you, Mr. Gursky, in connection with the alimony in Salito, did you request a specific amount for attorney fees?
No, sir. Not a specific request.
Okay, all right.
But 15 would have been a reasonable number.
Anything further, Mr. Gursky?
No, sir.
Thank you. We'll hear from Mr. Bryant for rebuttal.
Thank you. The assertion that the issue of VA money and as it relates to alimony somehow drove up the cost of litigation considerably is an unreasonable, in fact, it's an impossible standard to use, because a trial court judge does not sit in on a mediation. A trial court does not sit in on settlement negotiations. In fact, those things are inadmissible by the rules of evidence. So for a trial court to conclude or to even fathom that as a reasoning is an impossible thing for any court to do. And specifically in this case, there's no evidence, nothing in the record to support that that is the case. Now, Mr. Gursky's assertion that wife's bills might go up because of potential medical costs, she's covered under the 20-20-20 rule, and that's in the evidence. And that's going to cover her on medical insurance through TRICARE, some of the best insurance for the rest of her life, regardless of what happens to Mr. Ball. The comment that he has $5,000 in retirement, that's not true, or $5,400. Over $2,000 is going to his ex-wife by agreement, as she should get. And also $400 of it's going to pay an SBP, a survivor benefit plan that will pay wife a substantial amount, in fact, more than the retirement, should Mr. Ball pass away before Ms. Ball. If you take Ms. Ball's job income and take it out, let's say she did retire after the final decree, that's $1,300 of salary taken out. That still leaves the difference between her alleged need of $2,000 that is covered by the retirement. You take away $1,300 of it, her job, if she retired, that's still a lot less than the $2,000 awarded by the trial court. Her need is much more substantially met than the full $2,000.
Let me ask you, Mr. Bryan, before you run out of time. I understand the VA disability benefit is not a marital asset. All the cases say that. It's just like income, like your future income is not a marital asset. Now, but in this case, we're not talking about future payments. We're talking about past payments that accumulated in an account. Why is that not a marital asset?
Because it's VA, it's treated as separate. And so it goes into an isolated account, just like Ms. Ball had an isolated account from an inheritance. Both are considered separate property. And as long as you maintain them as separate, they don't get transmuted into a marital asset.
Well, what case says that? What case do you cite to support that view? Because as I read the cases, they say that these future payments are not a marital asset. They don't really address this issue of an accumulation of past payments. It would be like income. Your income is not a marital asset, but if you accumulate income in an account and you didn't spend it, that becomes a marital asset that you divide at the time of the divorce. Why isn't this treated the same?
And I can't find any case law that would say the opposite of our position. I can't find any that says you do split money that has the VA nature. I mean, the federal law has made VA a very protected special class of money, of an asset. And our case, I mean, there's no case law that shows you divide that like a marital asset. It is separate when it comes in, and it stays separate, assuming you don't commingle it with, your spouse's belongings, assuming you maintain it separately, just like you would an inheritance like Ms. Ball did in this case.
Is there anything in that federal statute or regulations that say that this accumulation of past VA disability benefits is not a marital asset?
Not in the federal statute that I'm aware of.
Okay.
Any further questions from the panel? Hearing none, thank you, Mr. Bryant and Mr. Gursky, for your arguments this morning. We will take the case under advisement. Mr. Hibner.
This honorable court is now in recess until 10 a.m.
All right, counsel, you're free to exit the meeting.
Thank you.